Court against the Teamsters Union Pension Fund. Mr. Trapp.
Thank you, and may it please the court, Mark Trapp for appellant. 10 years ago, the parties asked the arbitrator assigned to hear this case, the central legal dispute, to decide the central legal dispute, which was submitted to be whether the steel mill addendum covers the LISCO work. Notwithstanding the fact that the express written terms of the steel mill addendum were limited to steel mill operation work, and the parties stipulated that the LISCO work was not included within that definition, the arbitrator determined that the parties had adopted that written agreement to apply to the LISCO work. He thus held that my client was required to make contributions under that agreement that were forbidden by the express written terms of that agreement. Although the district judge acknowledged that he struggled with the decision and that it was close and could have gone either way, he ultimately affirmed the arbitrator. That question is now before your honors, and your review of that legal issue is de novo. Whether or not an obligation to contribute exists under a collective bargaining agreement is and always has been determined by the written words of that agreement, and it has never been determined by unwritten understandings or conduct of the parties.
I'm a little puzzled by the assertion in that form. Never been determined by unwritten things? Isn't there a long line of cases saying that people can adopt a collective bargaining agreement by conduct?
There is, Your Honor. There's a
Right.
very long
So
line
you
of
have
cases.
people bound by a collective bargaining agreement, although their name isn't on it. They've never signed.
That is correct, Your Honor.
Well,
What I meant
so
by
I think you need to make your point a different way.
I'm sorry, but let me clarify my point. When I say it's never been determined by unwritten understandings or conduct, I mean it's never been determined to be contrary to the written terms of the agreement. Every time that any court has used conduct to enforce an agreement, it has always been consistent with the written terms of that agreement. And I will
Except
stand
with respect
on
to who the parties are.
Sure, and I'll get into that, Your Honor, because I think that whose ox is gored makes no difference, because the statutes that Congress has written have very clearly say that the written terms are what determine the contribution. And I don't think that it can really fairly be otherwise, not for my client's sake or for the fund's sake, because funds would ultimately be harmed if the written word were not sacrosanct in ERISA disputes, as it is, and again, as it always has been. Many employers would choose not to participate in such plans if they knew that they could not rely on the written words, but the funds could. So the funds could either adopt the written words if they preferred to, or adopt unwritten conduct or some supposed understanding contrary to the written words, as long as they felt that that benefited them. That would ultimately harm pension funds, and that is precisely why Congress passed Section 302 of the Labor Management Relations Act, to make it clear that you could not contribute to a pension fund without a written agreement that provided the detailed basis, and a fund could never accept contributions for which there was no written obligation to contribute. And here again, there is no written obligation to contribute. The written terms expressly exclude the contributions that are at issue here. And this court has said in the Joe McClellan case, no matter what.
What do you think the consequence of your clients, what you describe as illegal contributions? What is the legal consequence of making illegal contributions to a pension plan?
I would say that the question is whether we're obligated to do so, and I would say we cannot be obligated to do something that's illegal.
On your view, all of the contributions made for the LISCO work were made in violation of federal law. That's fine. You seem to think that this gives you some benefit now. Why is that true? Why doesn't it just mean you're subject to criminal prosecution?
Because the question before the court is whether we're obligated to make that contribution. And I would submit that, as Your Honor is I think, stating.
It's not the collective bargaining agreement that makes this obligation. It's the Multi-Employer Pension Plan Amendments Act, which provides for withdrawal liability. Your premise, it's an unargued premise, seems to be that if the contributions were illegal, there cannot be any withdrawal liability. What's the basis for that contention?
Quite simply, Your Honor, that contributions that would be illegal, you cannot be required to do something that is illegal. And
no, the contributions were illegal on your view. Withdrawal liability is not illegal on your view. Why is it that making illegal contributions frees you of withdrawal liability, which is imposed by statute, rather than by a collective bargaining agreement?
Okay. Because the Multi-Employer Pension Plan Amendments Act requires, in order for a contribution to be counted as a contribution-based unit, you have to have been obligated to make that contribution. Otherwise, people could avoid withdrawal liability simply by not making contributions. Or they could continue contributions that are not required and avoid withdrawal liability that way. The determination is whether you're obligated, not whether the fact that the contributions have been made or not. And that's very clear throughout all the Multi-Employer Pension Plan Amendments Act cases. And here, it was clear in this case. We actually argued that point in front of the arbitrator, and he found for us, and it's already been decided, and the parties have since stipulated that if we were not obligated to make these contributions, then there can be no withdrawal liability. That's been stipulated by both parties. And here,
I don't think you can stipulate a point of law.
well, I mean, it was already decided by the arbitrator, and it's been.
You're not accepting the arbitrator's other decisions.
But we did accept that one. That was never appealed by anyone, and that was never taken up as a point to be argued. Everybody agreed that you had to be obligated to make the contributions in order for them to count, and that's a statement of law that is not contested or contestable. That's you have to have been obligated. Otherwise, the Multi-Employer Pension Plan Amendments Act would fall on its face. Employers could manipulate it however they chose, simply by making contributions or not, and that's not how the law turns. And ERISA, throughout ERISA, in whatever context you're talking about, whether it's benefits or Multi-Employer Pension Plan Amendments Act or Section 515 contribution cases, which are maybe the most popular cases in federal court, the written terms of the agreement are always and everywhere central to the dispute. And I would say that prior to the district court's ruling here, there has never been a case like this. There has never been a case. This goes back to my point from earlier, Judge Easterbrook, where I said that it's never been determined by unwritten understandings or conduct. I modify that to mean it's never been determined by unwritten understandings or conduct that is contrary to the written terms of the agreement. And I don't know why any pension plan would want it to be otherwise, because if employers realize that they are not allowed to rely on the written terms that they negotiate with the union and put in writing and sign, as we did here, and then the union can come along and force, cajole, corral, whatever you want to call it, and have our clients make contributions that are outside those express written terms, that, in my view, clearly violates Section 302 of the Labor Management Relations Act. And I don't know how it could be otherwise. I think if we step back and see that if we were here, if I was here, Your Honors, and we had reached an agreement with the union to not contribute for work that was clearly covered, I think I would rightly be laughed out of the courtroom, and Your Honors would say, that's clear that you cannot rely.
At least you would be laughed out after Gerber Truck. We had to sit on banc in order to resolve that issue.
Yeah, and Gerber Truck, Your Honor wrote Gerber Truck and made it very clear.
That's irrelevant.
Your Honor made it very clear that...
That is irrelevant.
Okay,
You don't want to make ad hominem arguments.
Gerber Truck made it very clear that any unwritten understandings contrary to the writings are not enforceable. I think the quote was, the Labor Management Relations Act and ERISA prevent a court from giving force to oral understandings between union and employer that contradict the writings. It's undisputed here that this agreement, so-called conduct, whatever the tacit understanding, which was really just fueled by making those contributions under duress, contradicts the writings. The writing in this case specifically says this agreement shall apply to the steel mill operation work only, and that's bolded, it's underlined, it's first sentence of the agreement. That determines everything about the agreement. The fund in its brief said, well, that's just a little flaw on the face of it. The work jurisdiction clause of a collective bargaining agreement is the end-all be-all of that agreement. It determines what work is covered by that agreement. And here it's specifically limited. And by the way, the union were the ones that insisted on that. Then lo and behold, we get some work that's outside those terms, and the union refuses to bargain a new contract and says, apply that one. I would submit that under Section 302, Congress never intended to allow a union to secure a narrow written...
What in the world does it matter what members of Congress intended? And how did you get any private access to their thoughts?
You're right, Your Honor. I take it back. I would say that the Section 302 express language...
I want to know what the statute provides.
Section 302 it states, it shall be unlawful for any person to request, demand, receive, or accept, or agree to receive or accept any payment, loan, or delivery of any money or other thing of value unless the detailed basis on which such payments are to be made is specified in a written agreement with the employer. And as Your Honor pointed out, that's a criminal statute. I think that there has to be a written agreement. There's a case from the Second Circuit, the Moglia case, says there has to be a written agreement. Any contributions without a written agreement that provides for those contributions are absolutely forbidden, it says. And it goes on to say this is not a minor technicality when one party might be otherwise estopped. There has to be a written agreement. And going back to my earlier point, I would submit that that statute precludes a union from securing an agreement on a narrow basis, which is what happened here, and then going around and applying it to other work to which it was never negotiated to apply. I think that's not only fundamentally unfair, it blatantly contradicts the Labor Management Relations Act, Section 302. It would allow unions to say, don't worry, guys, just sign here. You only need to cover these 3 employees. We would sign the agreement, and then the union would say, hey, you know what? You need to cover those 10, 15, 20 employees, even though these written words do not cover it. And if they successfully secure it, then a court would uphold it. I can't imagine that that's the case when the written word is always and everywhere sacrosanct.
Mr. Trapp, if we reverse the district court on this adoption by conduct argument, are there any facts supporting a second contract involving the Levy Company work?
What do you mean by the second contract, Your Honor?
Supporting a second contract. Any facts supporting any agreement with regard to that work?
It was stipulated before the arbitrator, and it's never been contested, that the contract with the Levy folks, we could never get it, and it was just stipulated that the LISCO work was not steel mill work within the terms of the steel mill operation work that were covered by the steel mill addendum. So it was expressly excluded. It was meant to be that way, and the union insisted that it be that way, and that's what we did. And it's been stipulated further, Your Honor, here that if the legal issue here is decided, if you affirm the district court, that's it, obviously. If you reverse, then that means that there's no withdrawal liability. As I said, that issue was already decided by the arbitrator, and the fund has taken the position in its briefing that if there's no obligation to contribute here, then that means that there could have been no withdrawal liability. Because, Your Honor, those contributions were what raised the supposed contribution base units to a very high level. When the union later went on strike against a different company, not my client, and we lost the work, the contributions fell. And so not only did we have to pay for contributions that were not required by the written agreement, 7 years later, the pension fund showed up and said, now you owe us withdrawal liability. I submit that that's unfair. I see I'm into my rebuttal time, and I'd like to reserve that if I could.
Mm-hmm.
Thank you. very
Certainly,
much.
counsel. Mr. Weishaupt.
Yes. Good morning, Your Honors. May it please the court. My name is Joe Weishaupt. I represent the trustees on the fund in this case. I'll refer to them collectively as the fund. Your Honors, we're here because Bulk wants a loophole, the kind of loophole this court has warned against. They're now claiming the steel mill addendum did not apply to the LISCO work. At the time
It
the
seems
work,
quite obvious that its language does not apply to the LISCO work. Now, my question for you is in some ways the same as the one I had for Mr. Trapp, but from a different angle. I understand there are a lot of cases saying that an employer can adopt an existing collective bargaining agreement by conduct. Are there any cases saying an employer can change a collective bargaining agreement by conduct?
there is not a specific case, but the class.
When you say not a specific case, I think you mean not any case. I looked too. I couldn't find any. And isn't that a serious problem when you have a statute that says the agreement must be in writing? If you can make changes by conduct, then the agreement doesn't have to be in writing. Anything goes. That's a serious problem, is it not?
Well, as we see it, there was an existing contract.
But it didn't cover this work, right? Suppose the collective bargaining agreement says, at Ford's plant in Michigan, the following terms apply. And the contract says only Michigan. And then the union tells Ford to make the same contributions for Illinois. I mean, that's not adopting a collective bargaining agreement by conduct. It's changing it by conduct. And that's the problem we have under Section 302. Really, are there no cases? As I say, I looked, your brief doesn't cite any.
We feel the most similar cases are the adoption cases, and the reason.
Yeah, but in the history of labor law, now 100 years old, there are no cases about change by conduct. It's a serious problem.
There are cases regarding Section 302 that certainly say the writing can have certain imperfections, certain apparent non-applicability to the work. But this court in Bricklayers said the existence of the contributions plus a written agreement between the parties setting forth those contributions amount effectively ends the inquiry. And this relates back to the Section 302 analysis, in that the analysis has always been, what are the purposes of the writing? And the two key purposes here are to prevent union exploitation and to provide certainty, and so that every party can know the terms of the contract. In the Alaska case, the court said that the writing only needs to provide a sufficient safeguard against the illegal payments that Section 302 was designed to prevent. And now what we have in this case, we have the steel mill addendum. The steel mill addendum plainly says your pension contributions are $3.50 an hour, and they are to be made to the pension fund, my client. If you look at the letter written by Bulk's comptroller, Deborah Jones, to the union at the outset of the work, she acknowledges that for each hour of the work, they will contribute $3.50 to the pension fund. So this aligns with other Section 302 precedents that have found, for example, that an unsigned CBA can suffice as a Section 302 written agreement. An expired CBA can also do so. An unenforceable contract can satisfy Section 302, The fund's own trust agreement can be the writing demanded by Section 302, or even a repudiated pre-labor agreement can satisfy Section 302. This is all significant because all these analyses relate back to, is it certain and does it prevent union exploitation?
Mr. Weisapple, what would be
Yes.
the limits of the adoption by conduct theory? Would it apply to non-union employees? Would it apply to unrelated work? How, if we're going to go down this route, how do we circumscribe it?
Your Honor, for this case, I think what the precedents demand is all or a significant number of the adoption indicia being present. This court has used for those indicia the payment of union wages, the payment of contributions, submission to your union jurisdiction, remission of union dues, and other agreements between the employer and the union.
And if we were to rule your way under that type of theory, what's the stopping point?
That would be a factual question. I would, it would have to be limited to contribution obligations, perhaps employee by employee, perhaps union membership would be a factor, and non-membership would exclude that
Union
employee.
membership, that's a prohibited consideration.
There's no clear pathway here for delineating the stopping point for adoption. However, what we have...
But you see that's why writing becomes so important, right?
I agree. Fortunately, in this case, we have absolute compliance with the addendum. We don't have really any lines.
Except for its provision about what work it covers.
That's accurate, Your Honor. But we do...
Well, right, you take another example. You have a hospital with a collective bargaining agreement for a group of nurses.
Mm-hmm.
Union demands that a totally different bargaining unit, say orderlies, be covered by the same pension plan. The hospital goes along. Does that satisfy the writing requirement?
That would not.
Why?
Because there's no... Here we also have the bargaining history for this work and these workers. In that case, I don't believe there would be a bargaining history for the orderlies. We just have, in this case...
Might be, there might not be. But bargaining history doesn't sound remotely like agreement in writing.
Right. A bargaining history, however, would illuminate the employer's intent to be bound with respect to that group of employees, and would indicate some degree of assent to making contributions. Your Honors, again, this court has said repeatedly, we're not going to take a formalistic approach to binding CBAs in the adoption context. This court has always looked to conduct manifesting assent and the employer's intent to be bound, and this is the clearest element of this case, that the employer had before it the LISCO work. It was lucrative work. It was done by union members for the previous employer, and the employer here, Bulk, made a calculated decision to employ the terms of the steel mill addendum in order to get the work completed. That's simply a textbook case of adoption. And the fact that there was work jurisdiction language excluding this work is militated against by the fact that Bulk ignored the work jurisdiction language. Bulk simply imported these terms and put them on the work. Bulk could have at any point taken a more affirmative step than attempting to negotiate with the union by invoking the work jurisdiction language and saying, hey, this doesn't actually apply. And it's important that they paid the workers and treated the workers under the addendum. That's the key factor rather than their expressed desire to negotiate a contract, because this court in Robbins versus Lynch repeatedly referred to an actor's intent as manifested by their actions as the intent that controls. So asking for a new contract is not enough when you're keeping the contract in place that you don't like. And it's especially not enough after April of 2005, when the union wrote a letter and said, it's our view that the construction agreement and the addendum apply, and you should apply them to the work. And Bulk did not change its behavior. At that point, it's not only assent, it's assent in light of knowing that the adversarial party agrees with you. Bulk really is trying to have it both ways by getting the work done and now getting out of its withdrawal liability obligation. And we'd urge your honors to reject that. In terms of adoption versus modification, we see this as an adoption
If
case.
we hold that the contributions were illegal, what happens to the workers' pension credits?
The pension credits would have to be revoked if we went so far as ruling the contributions illegal.
Do you think there's any statute of limitations for that?
Very likely for the criminal aspect. I am not familiar with the,
It's 6 years, I believe.
that is the general one. Yes, I believe that would apply, Your Honor.
So it would be too late to revoke the pension credits.
Yes. And so if we lose the withdrawal liability amount, that would, again, that would widen the fund's unfunded vested benefits to the fund's detriment. The slate of I apologize. The hallmark of an adoption of a CBA is when there is a slate of terms in an existing CBA and uncovered workers, and the employer, by its actions, demonstrates its assent for those terms to apply to those workers. And that's why we see that as an adoption case. And additionally, adoption and modification differ in three crucial ways. First of all, adoption is a binary switch. When you have an adoption inquiry, you're talking about whether the employer switched on all the terms of the agreement to apply to the workers or whether it did not. Modification is in an ongoing contract, you have a change to a term or terms, usually monetary terms, and usually that sort of change kind of interferes with the plan's ability to plan its benefits. When you have an adoption, you're going on script. You have these terms, they're written, they exist, and you have a writing that confirms how you are going to treat the employees, and you are adopting it for those employees. Modification is problematic because you're going off script, and now there's nothing that really accurately describes what is happening with the employees and their entitlements. And finally, adoption creates certainty. Adoption recognizes the employer, not the employer and the union, specifically the employer is treating the work a certain way, and we can rely on that as legally binding against the employer, and the fund did rely in this case. Modification is uncertain. It creates a lack of certainty because now you have a discrepancy. In this case, the treatment of the steel mill addendum is far closer to an adoption under these elements than it is to a modification. Again, we submit this cannot be deemed a modification simply because of work jurisdiction language that Bulk itself ignored when it wanted the work done. That's the sort of loophole this court has warned against.
Counsel, what's your strongest case for adoption by conduct?
I'm sorry. For adoption by conduct is the Bricklayers case because it has...
Which case?
Bricklayers Local 21 from this court in 2004, I believe.
Yeah.
Because what happens there is some degree of compliance, including some payment of contributions, and that is found to be adoption. And then additionally, in that case, the employer also raised the written agreement requirement argument, and that was rejected because there was the agreement setting forth the payments, the actual payments, and the court looked at those and said, those match, and that ends our inquiry.
Yeah, well, that's factually quite different than this case, right?
It differs in terms of a CBA being unsigned versus a CBA with work jurisdiction language that, read in a vacuum, would not encompass this work. Your Honors, opposing counsel made some comments regarding the possibility that funds would be hurt down the road by the position that we're taking. Section 515 of ERISA was passed as part of the Multi-Employer Pension Plan Amendment Act in 1980. The intent of that act was to not let employers repudiate their pension promises and slip away without paying, and to simplify the type of litigation we're engaged in here. Thus, it makes sense that Section 515 has never been used to relieve an employer of its liability when the employer has adequately demonstrated its assent to the terms in question. In fact, the Sixth Circuit in the Oren versus Scassa case from 2015 specifically said, Congress chose to give funds the upper hand in Section 515 collection litigation. That is from the Sixth Circuit. This circuit's precedents have aligned with that idea precisely, specifically the recent Trans-Service case and the Gerber Truck case from 1989. There's extensive discussions about the employer and the union being bound by the writing. and the fund being able to rely on the writing when the employer and the union, or at least the employer, attempts to contribute lesser amounts than the writing calls for. These cases do not stand for the proposition that an employer can repudiate its adoption of an agreement and disavow its contributions based on some imperfection in the writing that it adopted. There's also language in Trans-Service, Gerber Truck, and other cases regarding the need to protect the fund's legitimate expectations so that they can plan their benefits, so that the funds themselves are financially secure. Those are considerations that are specific to pension funds. These cases do not reflect a similar concern for the employer's financial well-being, and that aligns with congressional intent and the purpose of the statute.
Oh, how do you know what is in the head of members of Congress? And why do you think the contents of their heads matter?
That's fair, Your Honor. That's
The Supreme Court keeps saying over and over that we go by the language of the statute. If you could cut open members of Congress's heads, you wouldn't really get anything helpful.
probably not, Your Honor. Perhaps the real-world context immediately before the passage of MPPAA in 1980 is helpful, and I think Congress recognized that in coming to the view that these procedures should be accelerated. And that's not just the intent of Congress. That's how the cases have been.
Boy.
That's how the
Hard to
cases have
stop
been.
talking that way, isn't it?
Yes. Your Honor. That aligns though with how the cases have come out, how courts have reflected on what the statute means. And in this case, the concerns are very well placed because, again, Bulk imposed these terms unilaterally. Bulk imposed them. Bulk imposed $19.50 an hour as a wage. That matches the addendum. Bulk imposed $3.50 an hour to my client, and that matches the addendum. Bulk imposed $5.12 to a health and welfare fund, and that matched the addendum. The fund, under any legal theory, was entitled to rely on these overt actions that matched an existing writing, the steel mill addendum. There's no case that says that Bulk, that the fund erred by relying, and there's no case that says that Bulk can repudiate what it has done. Additionally, labor law generally supports the finding of a contract between Bulk and the union, because after all, if the steel mill addendum is not that contract, then the union is out in the cold. The union dues were deducted and remitted in error, and all the ways that Bulk treated the employees as union members were inappropriate and incorrectly founded if the steel mill addendum did not apply. Labor law cases.
I'm lost. Being a union member and having a collective bargaining agreement are different things. They were still union members whether or not their work was covered by a particular collective bargaining agreement.
That's correct, Your Honor. The point I'm attempting to make is it would be an odd result, an extremely odd result, if all the terms of a collective bargaining agreement were imposed, but then it was legally determined that nothing was in place at all. That's simply that's why labor law principles don't control specifically, but the general thrust of labor law militates in favor of finding that the addendum applied. To speak to the cross appeal regarding attorney's fees.
Maybe my grasp on labor law is slipping, but my understanding is that if an employer bargains to impasse, it can use whatever terms it last proposed to the union. And it seems that that's what Bulk did. The union refused to bargain, and Bulk used the terms it had proposed. Any problem under labor law? There's only a problem under pension law.
That would be consistent with labor law, Your Honor.
Yeah.
And that does bring us back to the Section 302 question, and it doesn't directly answer the Section 302 question, but Section 302 we believe is satisfied for other reasons because of the non-technical analysis that the court engages in, because the addendum provides certainty, and because there was simply no union exploitation here. As to fees, we believe the district court erred. Fees are presumptively appropriate where a party loses at arbitration, as Bulk did, goes to the district court and loses there as well. The standard is whether Bulk's arguments are substantially justified. In our view, they were not. In our view, there is, the facts presenting the case for adoption here are uniform, are far beyond what was present in Garriup and Bricklayers and the other adoption cases. So we believe attorneys' fees are merited and that the district court abused its discretion.
District court had quite a lot of candor to say it was a tough call for him, and on that basis, he was going to find it to be substantial. Right?
Understood. And certainly there is not a specific case under these facts where work jurisdiction language was the impediment to adoption rather than the lack of a signature. And I'm sorry, my time has run out. May I briefly conclude?
You can always finish answering Judge Brennan's question.
I'm sorry. Did I?
You did. Thank you.
Thank you.
Okay. Thank you, counsel.
Thank you.
Anything further, Mr. Trapp?
Thank you, Your Honors. Just a couple brief points. For 10 years, I've thought about this loophole argument, and I don't see how it can be a loophole. It's only a loophole if you assume the obligation, and that's the whole point, is you can't assume the obligation. You have to prove it and establish it by written terms, and the case that's been cited for that repeatedly, this line code case, referred to the loophole, and the loophole sought there was a departure from the written terms of the agreement, not enforcement of the written terms. Just a brief comment about the adoption cases, and particularly the Bricklayers case, which my colleague said was the best case for adoption. That case is totally distinguishable, as is every adoption case. The only reason you turn to adoption by conduct is if the parties did not sign the agreement. And here we signed it, we negotiated it, we wrote it out, we signed it.
Isn't that the difference between bricklayers?
Yeah, I think in Bricklayers, they didn't sign the agreement. The written words of the agreement specifically covered the work that was issued, and the opinion actually states that. The quote from the court was, "The parties do not dispute that the contributions made to the funds were made in accordance with the terms of the written CBA." And I have no quarrel with adoption by conduct. I'm very well versed in that, and I think everybody is, that's how it works. But here, it's a square peg in a round hole. It doesn't fit because we signed the agreement, the written terms do not cover it, and so any contributions made contrary to the agreement cannot be deemed consistent with that written agreement. And my colleague has said that Bulk ignored the written terms. Well, that's not exactly true. For 16 months, the entire 16 months, it's stipulated that we were repeatedly and continuously objecting and saying, you can't do this to us. This is not how this works. You have to negotiate another deal. And they refused. And then at the end, they just said, just apply that agreement. And that's, it's not fair to say that we ignored it. And particularly when we're here not ignoring it, why is it that the fund wants the court to ignore the written terms? I can't think that a decision from the Seventh Circuit ignoring the written terms is one thing, or the union ignoring the written terms is one thing. A decision from the Seventh Circuit is another. And finally, I would point the court to the Tackett decision from the Supreme Court, which says ordinary contract principles have to be applied here, and that the written term enforcement of the written terms is especially appropriate in the ERISA context. Both of those apply here because this is obviously the ERISA context.
I hope you see the problem from the union's perspective. They are on the hook for paying benefits to these workers. It's apparently too late for the pension credits to be rescinded, but the contributions Bulk made are insufficient. This is an underfunded pension plan, and that's what the 1980 amendments were all about. Leveling up when you contribute not enough to an underfunded plan. Your argument would be stronger if it had been made in time for the pension credits to be revoked, though I understand you probably didn't want to do that bad turn for your workers.
Yeah, well, here the contributions were made, so it's not as if that obligation was unfunded. Those contributions were made, and we never asked for them back.
Underfunded. The plan is underfunded,
The-
or there would be no withdrawal liability anyway.
That was true. I don't know if it is any longer under the American Rescue Funding Act, where they may or may not have gotten funding for that. You're right, it was underfunded, but it wasn't specific to these workers because we made those contributions. And so they got the money. Whether they apply the credits or not is, I think you're right, it's a 6-year statute of limitations under Section 1451. But finally, Your Honor, I would just say that, again, to end on Tackett, Tackett says that you have to apply ordinary contract principles. And applying the contract as written when the fund prefers it, but not when the fund does not prefer it, is not applying ordinary contract principles. And I would close with that, and I would respectfully ask Your Honors to reverse the
counsel.
decision of the district court. Thank you.
The case is taken under advisement. We'll hear argument now in the case of Wells against the Freeman Company. Ms. Schiff.
Good morning, Your Honors. May it please the court, my name is Mary Lee Schiff, and I represent the plaintiff appellant in this case, Alexis Wells. This is a case arising out of Lexi's employment with the defendant, appellee, the Freeman Company.
That begs the question, or rather, that is the question presented on this appeal.
I would agree with you, Your Honor. The case before this court is for a de novo review of the district court's summary judgment rulings against Lexi and in favor of Freeman on Freeman's motion for summary judgment and Lexi's partial motion for summary judgment. The district court dismissed her Title VII claims, her wage payment claim, and her intentional infliction of emotional distress claims. With this appeal, Lexi's asking that this court reverse those holdings, rule on her motion for summary judgment in her favor, and remand the case with instructions consistent therewith. Given the brief time I have before the court this morning and the number of issues that are involved in the briefings before the court, I plan to focus my intention on, or my arguments on, the issues of her employment relationship and employee status. Of course, if you have other issues or questions on the other issues, please ask. The district court dismissed Lexi's Title VII claims and applied those rulings to her wage payment claim because first, she did not prove she had a contractual employment relationship with Freeman, and second, even if she did, she was Freeman's employee or independent contractor, not Freeman's employee. Although this court has consistently told courts in this circuit that such issues are governed by federal law, and the place to start is with the economics realities test, the district court...
What in the world does that mean?
I'm sorry, what?
You refer to the economic realities test as if it were a thing, right? What is it? The world is full of economic realities.
Yes.
Cases like this usually depend on which ones matter, right? There is no written down economic realities test. It's a fantasy. We can talk about which things matter and why, but there is no such test.
I would disagree with you,
Oh,
Your Honor.
well.
This court set forth the test in Knight, and in numerous cases since Knight, saying that in cases where the employer-employee relationship is being considered under Title VII, meaning who was the employer and who was the employee, the courts are to use what this court established as the economic realities
And what is
test.
it? Tell me what it is.
Yes, the test balances 5 factors that apply agency principle to determine the economic realities of the working relationship, because the economic realities of the working relationship are not based upon a party's agreement. And so in order...
Is this something in the restatement of agency by chance?
Yes, I mean, when the court adopted it, and in your discussions, they looked at the restatement of agency. And as this, Your Honor probably knows, different circuits apply, they don't apply different tests. In this circuit, they have...
They use the same name for
Yes.
a variety of different considerations, which tells me that it's not a thing. We have to be thinking about what those considerations are. If you look at the restatement of agency, they have a totally different list. It's not as if there were some written down criteria that we could use. So you need to justify your argument rather than referring to this phantom.
Well, there are written standards. I mean, there's 5 factors that this court uses. Now, when you look at other courts, they use an economic realities test that may have 7 factors. But this court uses 5 factors.
The Supreme Court of Kansas, by the way, uses 12,
Yes, but if you look at those...
which just tells you it's not a thing, right? Stop referring to it as if it were a thing. Tell us what factors you think matter and how we should consider them.
Okay. The first factor is Freeman's control and supervision over Lexi. And that's the most important factor that this court looks at. And it's the factor that this court gives the most weight to. And with respect to the facts in this case, perhaps because the district court had already decided that Lexi had no formal relationship with Freeman whatsoever, the court devoted only 1 paragraph of its decision to discussing Freeman's control and supervision over Lexi. And in doing that, the district court ruled that Lexi set her own work hours. The work that she did for Freeman was simply random tasks assigned to her by Vaughn that she seemed to do on her own and at her own discretion. The district court therefore found that this factor favored Lexi's independent contractor status. However, in reaching this, we would argue that the district court did not thoroughly consider all the undisputed facts in the record, and the district court misapplied this factor because it didn't even look at the supervision component. This court has said numerous times that it is control and supervision. And in this case, the district court, although the court specifically found that the work Lexi did was assigned to her by Vaughn, the court didn't then address the issue of his supervisory status, which Lexi argued he was a supervisor under Title VII. The court's decision also is not supported by the undisputed facts in the record. For example, to support its opinion that Lexi set her own work hours, the district court cited to 3 lines of Lexi's deposition testimony pertaining to the time she started work on the 2nd day of her employment with Freeman. And in response to Freeman's counsel's question, did you just get up and go into the office whenever you woke up the next day? Lexi answered, after getting ready, yes. Based on this testimony alone, the district court decided that she set her own work hours. The court, however, ignored that the night before, her supervisor, Vaughn, sent her an email and told her, tomorrow I'm starting early, so when you are up and going, head to the office. I have a pile for you to start getting ready for next week. So Lexi therefore did exactly as her supervisor instructed. The district court also ignored evidence that he sent her an email and told her, be at my office at 1 o'clock, that's when you're gonna start work. He sent her an email and said, when you get to Orlando, let me know, we've got work to do tonight.
How does that differ than the interaction one would have with an independent contractor?
Well, an independent contractor, Your Honor, wouldn't be going to the office to do the work. The independent contractor, by the very nature of it, would set their own schedule, would set their own work hours, would tell Freeman, here's what I can do for you, here's when I can do it, here's how I'll do it, and here's how much I'm going to charge you for it. That's not the case with respect to an employee and or Lexi. She never told Freeman, hey, here's what I can do for you. In fact, Vaughn knew that she wasn't an independent contractor or didn't operate as a separate economic entity that provided production assistance services to companies like Freeman. I mean, that's not what she was. And those are the facts that this court has to look at. She didn't say, I'm going to do this work and here's when I'm going to do it and here's where I'm going to be to do it. She was told by Freeman, here's what you need to do, here's where you need to be, here's when you need to do it, and here's who you need to do it with.
So your argument goes to the direction of the order and the content of the order.
Yes, and it goes to who supervised that. Who was the one that directed it?
Mr. Vaughn settled, correct?
I'm sorry, what?
Mr. Vaughn settled, correct?
Yes.
Was that settlement confidential?
Yes.
You may continue.
Yes. Let's look at another example with respect to the district court's opinion that Lexi did the work assigned to her by Vaughn on her own and at her own discretion. The record evidence does not support that. I mean, that's all that is an opinion. You have to look at the record evidence. I mean, it would be like, here's a hypothetical, or maybe what the district court was thinking, but you're right, I can't get into the district court's head. But Vaughn would assign her a task, similar to if I'm going to assign a task to one of my secretaries, and I'll say, here, I need you to review, revise, correct, and write up this brief. Well, I'm not going to sit over that secretary for the next 7 hours and watch her do that work. But that doesn't mean that she's an independent contractor. I assigned her the work. She's going to do the work. And if she has questions, she's going to come and ask me, and I'm going to help her get through that. That is exactly what Vaughn did in this situation.
If Vaughn, though, was supervising, say, a temporary employee, would he be doing the same stuff as he would if it was an employee? Someone who comes from a temporary employment agency. You have a secretary who comes in. That secretary on a temp basis is going to accomplish the same tasks that your full-time secretaries do, correct?
Yes.
Yeah.
Yes. And it's a question, would Freeman be the employer of that employee?
Correct.
Okay, I think that, Your Honor, gets into all the cases that the Seventh Circuit has ruled on as to joint employership. Is it the agency that sent the temporary employee, or is it the law firm that the employee works for and is directing? And with respect to Vaughn, I mean, he was asked specifically, did you direct Lexi's work? And he said, yeah, based on the changes I've seen, understanding that the majority of the work he assigned to her was to look at what Freeman calls pull orders, which are these equipment lists and audio-visual lists for each room that would be used at the Vive event. And she had to go through those lists and reconcile them with what Freeman had on their budget. All right? And with respect to that work, he said, yeah, I directed it based on the changes I've seen, making sure she knew what days she was working on. There were multiple days, multiple equipment lists. She was going through them, so I was making sure that her days aligned. That would have made sense to make sure she knew what she was looking at. So there's also, the district court also ignored numerous other undisputed facts that establish Freeman controlled and supervised Lexi's work These facts are set forth in 19 bullet points in appellant's brief on pages 29 to 31. So with respect to the first factor, which is the most important factor, the district court should have found that favored Lexi's employee status, not her independent contractor status. Turning to the second factor, Your Honors, which focuses on the type of job Lexi was hired to do and the skills she needed to do that job, including whether she acquired those skills on the job, the district court misapplied this factor. What the district court did is say, okay, she didn't need any skills to do her job, so I'm gonna find that favors employee status. But Freeman did not give her any training, so I'm gonna find that favors independent contractor status. That's not how this court applies that factor of this test, because on-the-job training is evidence of employee status. I see that my time's up, Your Honor.
No, you have a minute left.
Oh, I'm sorry. Okay. So the district court held the second factor was neutral, and it should have held that it favored Lexi, employee status. With respect to the third factor, the district court said that, I'm sorry. Okay. Which focuses on cost of operations. The district court said or found that the only cost that Freeman bore towards Lexi was a payment for 2 meals. That's absolutely wrong. I mean, the undisputed evidence established that Vaughn told her Freeman would reimburse her. Vaughn paid for her transportation to and from the venue site. Freeman gave her a computer.
Thank you, counsel.
I'm sorry. Okay, thank you, Your Honor.
May it please the court.
Mr. Paul.
Thank you. May it please the court. We acknowledge that the allegations against Mr. Vaughn are disturbing, but as Judge Brennan noted, Wells has settled with Vaughn, so the critical question now is whether Freeman can be held liable for what Mr. Vaughn allegedly did. It can't be. Vaughn had known Wells her entire life. She had done side jobs for him in the past, and he had been doing a side job that involved helping her become a model, something Freeman had absolutely nothing to do with. It is in this context that Vaughn asked Wells to come to Orlando for a one-time, one-week event to be a production assistant and a makeup artist. Wells admits they never agreed on the financial terms of any working relationship. These undisputed facts do not make for an employment relationship. At most, they make for an independent contractor relationship. Wells was to work for only a week. She received little instruction and no formal training.
Do you acknowledge that Freeman had at least apparent authority to hire Wells?
Freeman?
Yes.
Yes. If you're referring to Vaughn, no. Apparent authority is the authority that a principal gives an impression to the agent, or not the agent, a potential employee that this person has the power to hire. And there is no evidence that Freeman ever gave the impression to Wells that Vaughn had the authority to hire her.
You think apparent authority depends on direct dealings between the would-be agent and the principal, rather than another agent? That's what you're saying, that there's nothing that Vaughn might have said or done, and nothing Freeman might have said or done in relation to Vaughn that could leave Vaughn with apparent authority
Fair enough.
to hire Wells.
Fair enough.
You would be, I've already referred to the restatement of agency.
Yes.
What you're saying would come as a shock to the ALI.
Certainly, Vaughn could give the impression that he had the authority to hire Wells on behalf of Freeman. The problem is that there was no meeting of the minds on the essential terms, and the most essential term of all, of course, is compensation.
Yeah, that's a different matter, but it's not what I was asking. I was asking whether there was apparent authority to hire Wells.
Yes.
Now, we could then get to the question whether Wells actually got hired, and if so, as what?
I would agree with the premise, although I think it's important to note that the record is quite clear, and this testimony comes from multiple people, that Mr. Vaughn did not have the authority to hire and fire. But let's assume that he had the apparent authority to hire Ms. Wells. As I say, the problem is that there was no meeting of the minds. Wells admits that they never discussed compensation, and she was asked in her deposition, to this day, do you have any idea what your pay rate would be? No. It's difficult to imagine that she can demonstrate a meeting of the minds or an agreement on that essential term when she denies the matter was even discussed, and she says to this day she has no idea what she was to make. So there was no contractual working relationship at all. And then you don't even get to the question of, to use the Knight language, the economic realities of the situation. But let's assume that we get past the contract question and move to the factors that matter. This court said in EEOC versus North Knox School Corporation that the inquiry into whether someone is an employee or an independent contractor is a legal question for the court, and that just because some factors or facts may favor employment status does not preclude summary judgment. Now, as my colleague noted, this court has said that control is the most important factor. We don't dispute that. But given that the job commitment here was so short, that provides vital context for all of the other factors. So with your permission, I'll discuss that very briefly first, and then I'll move to control. So on the length of the job commitment, it's undisputed that Ms. Wells was to be retained for only 1 week, which strongly favors independent contractor status. She was still in college, on winter break, looking to make a little money and potentially further her modeling career by accepting this job. Companies don't go to the trouble of hiring employees for a week. They go to third-party staffing agencies like Mertz Crew and retain people as independent contractors, which was precisely the plan here. Moreover, there was no specific expectation or guarantee of future work beyond this 1 week event. This court said in North Knox School Corporation that the bare expectation of work without a corresponding commitment to provide that work from the defendant is not indicative of employment status. And moreover, any future work opportunities would have been entirely project-based, which establishes, again, an independent contractor
Do you
relationship.
think associates at a law firm are independent contractors?
No,
They aren't guaranteed any work. They
Well-
are employees at will. What work they do depends on what clients come to the firm.
I understand, but when we're talking about project work, if there is no guarantee of future work and no corresponding commitment to provide future project work, that cannot be indicative of employment status. As to the issue of control, there has to be control both as to the result achieved and the details by which that result is achieved. Here, the control, it's undisputed, was very minimal, which again strongly favors independent contractor status. Ms. Wells received 20 minutes of instruction and no formal training. Otherwise, she worked independently and at her own pace. Yes, of course, she was assigned particular projects. But as this court noted in Suskovich, that's not sufficient to make someone an employee. You have to tell independent contractors what to do as well. There's no evidence Vaughn checked her work. The evidence is that he told her to double check her own work. And Wells did in fact set her own hours, and those hours were irregular. The first day she worked 1 to 5, the next day 10:30 to 4:30, and so on. And then at the event, Wells admits Vaughn didn't give her a specific time to show up. This flexibility and irregularity of working hours is again indicative of an independent contractor relationship. And regardless, as this court said in Suskovich, merely setting a work schedule and requiring a person to be at a given place at a given time is not sufficient to make that person an employee. You have to do those things with respect to independent contractors as well. This relative lack of control indicates that what Vaughn was ultimately interested in was getting the work done, the result, not the details by which that result was accomplished. We then come to the tools and equipment factor, and I think it's helpful to break this up into two phases: pre-event work and then work at the event in Orlando. As to pre-event work, there's no evidence that Freeman provided any equipment for Wells to do her work. Vaughn's office was at Wells Church. There's no evidence Freeman paid for that space. Instead, the only evidence is that Vaughn made a monthly donation to the adoption agency that was housed in that church in exchange for the space. As to the computer she used, Vaughn testified without dispute that she used a GLAD computer. GLAD is the adoption agency. It wasn't a Freeman computer. And finally, as to the incidental supplies she used, paper and pens, she said she grabbed them from one of the offices in the church. Whether it was Vaughn's office or another office, she couldn't remember. Now, at the event, she borrowed a computer for one afternoon, the second afternoon that she was there. But critically, she was not given login credentials as an employee would normally get. Someone had to log in for her. The computer was locked to the desk, and many others had access to the same bank of computers, including independent contractors. Finally, while we're here, I think it's notable that Ms. Wells was initially asked to do makeup work. She had her own business doing makeup, which she promoted on social media, and she had her own makeup kit, her own tools. That, again, is indicative of independent contractor status. As to method and form of payment and benefits, the district court said that this factor slightly benefits Wells because she was to be paid hourly. We don't contest that. Finally, as to the kind of occupation and nature of skill required, the district court said that this factor is neutral. On the one hand, certainly her job did not require a lot of skill, and what skill it required she had already obtained from doing other jobs, including a side job for Vaughn. On the other hand, balancing that out, and this factor is relevant, contrary to my client's statements otherwise, if you see the Knight and Worth case, the court considers both skill and training. As to training, she needed little instruction, she received no formal training, and she didn't receive the time-consuming training that new employees at Freeman typically receive. So that all balances out. I would just note, though, that again, she was asked to do makeup work, which does require a certain level of skill. So that factor is either neutral or, I would say, slightly favors independent contractor status. All of this is consistent with the undisputed testimony from 3 different people that when Freeman retains production assistants, it does so as independent contractors. Wells was not onboarded as an employee. She was to be processed through Mertz Crew, a third-party agency, and she was to submit an invoice for her work at the end. Employees don't do that. Independent contractors do. I'll end, with your permission, just touching on the tort claims, IIED and negligent infliction of emotional distress. As the district court indicated in its order, Ms. Wells, and I encourage you to look at her summary judgment brief for this point, did not really engage with Freeman on these claims at all. She did not engage with the elements of these torts. And so she did, in fact, waive these claims, but on the merits. As to intentional infliction of emotional distress, the evidence is undisputed that Freeman did not intend to cause extreme emotional distress. And here you have to remember that this issue is about Freeman's conduct, not Vaughn's conduct. And Wells admits in her deposition there was no reason to believe that anyone at Freeman intended to cause her emotional distress. Secondly, Freeman did not commit extreme and outrageous behavior. Freeman's behavior was not, and this is the standard, utterly intolerable in a civilized community, and Wells didn't argue otherwise. This is, in fact, a matter for the court to determine in the first instance. That's what the Restatement of Torts, Section 46, Common H says, and that's ultimately what the Indiana Court of Appeals concluded in the Westminster Presbyterian case. It decided whether conduct was extreme and outrageous as a matter of law.
Mr. Paul, in your opinion, is Indiana law stricter or the same as that Restatement Second, Section 46 requirement?
I think it's generally the same and relies heavily, and it has from the beginning, on that restatement section. Yeah. Now, Wells cites 3 allegedly false representations for her intentional infliction claim that Freeman made at the EEOC in its response to her charge. And I do want to address those allegations directly. And her argument seems to be that Freeman was attempting to cover up somehow the fact that Wells was at the event and that she was somehow Freeman's employee. And maybe the most important allegation she makes is that Freeman created a fake expense report, and by doing so was trying, again, to conceal Wells' presence at the event. Here's the problem with that. While it was not Vaughn's expense report, it was a report of Vaughn's expenses, and no one disputes that. Secondly, Wells was listed as a business guest on that report because she was not an employee. And in fact, if you look at that report, that is how Freeman lists independent contractors. You'll see Lori Brennan's name on that report, and you'll see Lloyd Ellis's name on that report. Ms. Wells acknowledges that they were independent contractors. They are listed as business guests. And finally, that report notes that Ms. Wells' title was a production assistant / makeup artist. If Freeman was trying to cover up Wells' presence at the event, it's a very odd way to do it, by listing the work that she was exactly supposed to do. I see that I'm running out of time. In short, I would simply ask the court to affirm on all grounds. Thank you.
Thank you, counsel. The case is taken under advisement. Our third case for argument today is Geft Outdoor against Evansville. Mr. Blakelock.
May it please the court. My name is Rich Blakelock on behalf of Geft, asking that the court reverse the district court's entry of summary judgment and remand the case back for a trial on damages. I'd like to make 2 points today. First, under the pretext of an adverse variance decision, Geft was denied a variance in Evansville based on who it is, a competitor of another billboard company, and what it may have said, displaying advertising on that may be contrary to a local business shoe carnival. That happened because Evansville's variance scheme allows too much discretion, and it's that type of discretion and the risk of censorship that prior restraint doctrine is designed to prevent. Secondly, because Evansville's variance scheme is unconstitutional as applied to Geft, Geft should be entitled to damages for Evansville's successful effort at stopping that billboard. In Indiana, if you want to zone land, you have to have a variance procedure. One cannot exist without the other. This court said in Geft versus Monroe County, quote, "Zoning and variances go hand in glove. Zoning would be unworkable without the flexibility provided by variance," unquote. When Geft tried to erect the billboard, Evansville did not have a constitutional variance procedure in place as it relates to speech, which means that Geft had no right to regulate, that Evansville had no right to regulate the Geft billboard at the time. The billboard could have been erected. Unfortunately, the lease expired, and so we're left with a damages claim. As to the first point, in Geft versus Monroe County, this court expressed its preference for deciding these types of issues on an as-applied basis, and we believe this case presents the facts for this court to do just that. Evansville BZA's open-ended, undefined criteria that granted the ability to hide behind those provisions to deny GEF the right to speak, we believe are improper, which is what the district court ruled the first time, said that those provisions are subject to different interpretations. And we think there's ample evidence in the record to conclude that it did just that. We found no other examples of Evansville BZA denying would-be speakers the right to speak under similar situations as presented by GEF. The executive director of Evansville was unaware of any. The only difference between the 4 billboards that received variances similar to those that we did not get and us is the speaker and the possible message of the speaker, as evidenced by what was presented at the BZA hearing. And as I mentioned, we've identified 4 other examples where the BZA granted similar variances to billboard companies. More specifically, Costco and Shoe Carnival flexed their corporate muscles in Evansville and reminded the BZA how much money they had invested in the community, how many employees they have in Evansville, and how much they contribute in taxes. Shoe Carnival even suggested it may not expand its footprint in Evansville if this billboard went up. One of the BZA members then at the end thanks, it was exactly unclear who, but clearly to one of them, for everything you've done. Evansville did not want to upset its good corporate citizens and allow GEF the right to speak in the way that it had provided to 4 other similarly situated billboard companies. Shoe Carnival then expressed its concern that GEF would advertise for competitors right by it. And my point here is this is exactly the type of speech that the government should protect and not quash. I mean, what if Shoe Carnival was charging ridiculous prices? The BZA has now said the competitor can't put a board up in front of Shoe Carnival and point this out because it wants to protect that particular speaker and what it's doing. Lastly, one of GEF's competitors in Evansville spoke out about how the billboard would, quote, weaken its product. Again, what that results in is favoring those that are already there and what they're saying versus GEF and what it wanted to say. None of that is part of the statutory variance criteria, and all of the other similar variances were granted. We believe this is exactly what an as-applied challenge is designed to protect against, preferring one speaker over another and one messenger over another. The issue, of course, is we'll never get testimony where somebody admits that that's exactly what happened. We're prevented from doing that under our research because the BZA is a quasi-judicial branch and we can't depose them and ask them exactly why they made those decisions, which is why in the prior restraint context that we are asking for relief from from the district court and obviously now from this court. So we believe that the district court erred in concluding that we did not have an as-applied challenge on the variance. The second point I would like to make is that we don't believe that in Evansville, as applied to GEF, that Evansville can zone property in Indiana without a constitutional variance process, which, as I've just outlined, we don't believe is the case. Indiana statutory law requires that if a municipality is going to regulate property, it has to have a variance process. It's what's called as an escape valve. And the variance provisions are enabling statutes. The state of Indiana, through its law, has preempted the field of zoning through that variance provision. So Indiana Code 3674901A says as part of its zoning ordinance, the legislative body shall establish a BZA. It shall adopt rules, and then later in the code it says that it shall approve or deny variances. And the Strange versus BZA case, which we've cited in here, talks about how it is an enabling statute and that zoning ordinances, local zoning ordinance, may not override state law and policy. To be held constitutional, zoning laws must have the safety valve, and again, that preempts the entire field. We think the International Outdoor versus City of Troy case presents a similar situation here, or at least presents some similar law here, which is the variance is not independent from other provisions of the ordinance. Again, they go hand in glove. That court said that they are inextricably linked by providing a way of relaxing the very restrictions imposed by the sign ordinance. And it held that in the context of standing in that case. This court in Monroe County said they go hand in glove. So it's our position, if the variance procedure is unconstitutional as it relates to speech, then you have a situation in Evansville where somebody who wants to build a pool too close to the property line has a process that is fine, legal, to go through. Someone who wants to erect a billboard to exercise a constitutional right to speak does not. This cannot be the intent of the legislature who passed the sign code.
Do you have any decision of the Indiana Supreme Court that supports you?
No, it's the Strange case. I think it's a Court of Appeals decision that talks about that. But it did cite, without contradictory law, the proposition that zoning and variance go hand in glove, and you can't have one without the other. And so, touching a little bit on severance, a severance clause in an ordinance can't get around the fact that state law, which allows you to zone in the first place, requires both the variance scheme in order to allow you to zone at all. We think that elevates form over substance, and it would elevate the local ordinance over the United States Constitution as it relates to speech, and the Indiana State Legislature as it relates to the process for controlling the use of land. Lastly, it's our position that that variance scheme is unconstitutional. As I mentioned, we think this case mirrors in some respects the International Outdoor versus City of Troy case, which this court distinguished under the facts of Geff versus Monroe. But unlike that case, Evansville requires permits for signs. At the time we argued the Geff versus Monroe County case, the court had rendered that unconstitutional, and at that point, Monroe County was content not to have a permit. So Evansville still requires permits, and its permit provisions are content-based because they have to make a decision if you need a permit, whether or not it's commercial speech or not, as acknowledged by their director of zoning. Also, many of the exceptions here are content-based, which the district court in its first order acknowledged that they are content-based. There's things relating to garage sales, real estate signs, and so forth, which, as the court in City of Troy says, increase the risks that the BZA would discriminate based on content or the speaker. And then next, the criteria the BZA considers is replete with discretionary terms that are not defined, injurious to the morals and general welfare of the community. Use and value of the adjacent area will not be affected in a, quote, substantially adverse manner. And there's an internal memo from Evansville that we put in the record where they even acknowledge they're not exactly sure what that means. Practical difficulties created for the, actually it's the practical difficulties created for the property. It's that risk that those criteria will be misused that is the constitutional infirmity that is present here as applied to Geff. It's been used as a pretext for preventing disfavored speech, a competitor of a big employer, and disfavored speaker, Lamar over Geff. The criteria for rendering the variance procedure we believe are unconstitutional as applied to Geff, and the case should be remanded back down. In conclusion, it's for the government to properly regulate speech. It is not properly done so here. We often in these cases confront people saying, well, you're just trying to find a gotcha situation. I would respectfully submit that when there's such a fundamental right as free speech, the question should be reframed from the government's vantage point. Did the government properly regulate speech? And here, as applied to Geff, we believe it did not, and there are consequences for that. And unfortunately, it's not that we were allowed to speak, it's that in this case that we obtained damages. So I'll reserve my remaining time unless the court has any questions. Thank you.
Mm-hmm.
Mr. Severin.
Yes, good morning, Your Honors. Philip Severin for City of Evansville. I wanted to reframe some of the issues that the attorney for the appellant presented. And in particular, I found it interesting that the thrust of the argument and the crux of the argument is that Geff was treated differently from other applicants or other companies or entities or people who were similarly situated. And I think they have a huge preservation problem in this case. because if you look at the supplemental complaint, which is the operative complaint in this case, there's 3 causes of action. The first one has to do with the permits and the exemptions. And as the district court found in this case, GEFT has no standing because it was not seeking to have any of the exemptions set aside that were content-based that would affect its ability to have the billboard. The second cause of action is that the procedural safeguards, that includes the variance provisions, are an unconstitutional prior restraint. And they say there that it allows too much discretion. That is a facial challenge. The third cause of action is challenging the BZA decision. That is the as-applied challenge. And I want to point out very clearly that the third cause of action was dismissed voluntarily by GEFT. So there's nothing in the supplemental complaint that sets forth the cause of action on which they are now seeking to have the district court reversed. And even if it had, I would point out that in the summary judgment motion, there is no argument that they're making today before this court in terms of differential treatment. And I would call the court's attention to the reply brief as document 171 in the district court's record at pages 10 and 11, where they point out that they're talking about these other instances in order to show that or support their argument that the variance allows too much discretion, that it allows the city to pick and choose. But on the bottom of page 2, they say that this evidence is material because it is circumstantial evidence of the lack of objective criteria, which is a facial challenge. And then when we get to the district court's opinion, we see there's nothing in there about what they are arguing today, very clearly because it was not presented. Then we get to the opening brief before this court, and the arguments there is a facial challenge, both to the permitting, which Mr. Blakelock did not present at argument today, so we rely on the briefs, but also a facial challenge to the ordinance and then seeking a severance. You don't have a severance unless you have the facial challenge, because if it's as applied, then you don't have it struck down. It isn't until after the opening brief is filed in this case that this court decided the Monroe County case. And Monroe County case very clearly sets forth its reasoning that the criteria for the variance, which are qualitatively and conceptually indistinguishable from the variance provisions in this case, are not overly broad, they're sufficiently narrow and objective. And if you compare the variance provisions in the ordinance in Evansville with the ones in Monroe County, for example, the very first one, the approval will not be injurious to the public health, safety, and general welfare of the community. That's exactly one that Mr. Blakelock just pointed out. Well, in Monroe County, they said that that is permissible. The point here is that variances, by definition, are discretionary because it's allowing for variations, quite literally where the word variance comes from what the otherwise would be a rote application of the sign standards. And the Thomas versus Chicago Park case decided by the Supreme Court says that variances promote speech, having variances promote speech, when the purpose of having the restrictions in the sign ordinance are not met by the particular circumstances, whether it's the property or the applicant or what have you. And they also say in that case, the Thomas versus Chicago Park case, that it is constitutional in terms of the discretion where it allows for meaningful judicial review. And again, I go back to count 3 of the supplemental complaint, where one of the grounds on which they say that the BZA, in which they're challenging the BZA opinion, is contrary to GEFT's First Amendment rights. It's right there, and it was dismissed. And again, if the second count, which is an unconstitutional prior restraint, when you get to the point of applying the variance, you're not arguing that it's an unconstitutional prior restraint. You're saying that it was an abuse of discretion, which this court said very clearly again in Monroe County, when saying that that variances by definition are discretion. It says, as long as the laws at issue do not chill speech, we should prefer that any abuse of discretion concerns be resolved through as-applied challenges. It isn't until the reply brief by the appellant in this case that we have the argument presented to this court today about the differential treatment. I can go into the differential treatment, but again, I want to emphasize their position that quite clearly was not preserved. The Geft acquired the lease on property that was along I-69, major thoroughfare in Evansville, and there's reference in the record to this being the gateway to Evansville. There was already a billboard on that property. They sought a variance in order to exceed the size and the height restrictions in the sign ordinance, as well as the spacing from the existing billboard. So it's almost as if, I mean, there's the adage about you can't move next to an airport and complain about the noise. Well, they acquired a lease on property where they knew they were going to have to get a variance and then complained about the sign standards and the variance not being granted, when there's plenty of properties within the city of Evansville where they could have gotten their billboard, save for the size and height restrictions, which they're not challenging in this case as far as being inappropriate. Mr. Blakelock has cherry-picked different things about what people have said. Of course, people are going to come before the Board of Zoning Appeals and say things that are in their self-interest. That doesn't mean that that then is the Board of Zoning Appeals making a decision on that ground. But since he mentioned a few, Shoe Carnival and Costco, they have large headquarters there, and their concern was that another billboard, a second billboard on the property, would impair the visibility from I-69. The competitor, Lamar, I would point out that the evidence in the record, they opposed another variance for another company at Ruston Lane, which was one that was granted. The Ruston Lane was 9 miles away. It was in an industrial area. There were no adjoining property owners that were complaining. And then there's another property owner next to this one, Promenade, that talked about the spacing limitation between billboards being a legislative compromise to reduce blight, that they should follow the legislative compromise. But none of these arguments, none of them, not one of them was presented to the district court in terms of, well, we were treated unfairly compared to someone else that was similarly situated. And again, this is an abuse of discretion standard. You can have the same facts or the same property, and yet there might be reasons why it's within the abuse of discretion, the same as this reviewing court reviewing maybe evidentiary decisions or other decisions by a trial court. It's not like there's one answer to those. And I would also point out that even as an as-applied challenge, it is not, they have not met that standard. And I would point the court to the H.H. Indianapolis case, which is cited by this court in Monroe County. That case, briefly stated, involved an adult bookstore that wanted to have a variance to have their business in a certain location. The court said that, well, no, that was not a violation even as applied, because the city of Indianapolis did not prevent the business from speaking, because the adult bookstore could operate in other places in the city. The same thing that we have here. It's just limiting where they could speak, not what they could say or how they could speak. And I might point out the Indianapolis case says very clearly, the city has simply told H.H. that it cannot operate in C3 district while also providing numerous other avenues for speech. So this only resulted in the city of Evansville saying you can't have your billboard here because of the size and height. We're not going to give you those variations, and also the spacing from other billboards. So I would say even if they had made an as-applied challenge, they have not met it here. An as-applied challenge doesn't mean I have an absolute right to speak how I want, where I want, and when I want. No, it means you can have reasonable restrictions, and as long as you have variances that are then allow for meaningful judicial review based on Monroe County, I don't see how this court could find that these terms are unduly broad or not sufficiently objective. I did want to comment on the variance and in terms of the argument for severance. The Indiana statute 36-7-4-918.5 is the one that talks about variances for developmental standards. What this section says is that the Board of Zoning Appeals shall approve or deny variances, and then it gives criteria. It also says the board may impose reasonable conditions as part of the board's approval. If in fact the variance was determined to be unconstitutional on its face, which again would be a necessary predicate to striking the or finding that the variance procedure itself or the provisions themselves, is unconstitutional, and it can be severed because you still have the terms and the provisions in the statute that would apply. The final thing I'd like to say is that in reality, what they're making is not an as-applied challenge, and again, it hasn't been preserved, but they're not making one even now, because the H.H. Indianapolis case talks about what is required for an as-applied challenge and how if the city is not preventing you from speaking based on the enforcement of these sign standards, then you can speak somewhere, just not here and in this manner. Typical time, manner, place, restriction, which is perfectly constitutional. But I would say that what they are presenting instead is more of an equal protection challenge. What they're saying is that I was treated unfairly as compared to others. That doesn't mean that that could be a claim, that even if you can speak somewhere else, that you're letting them speak here in the same manner, in the same time that I wanted to speak. But that is a selective enforcement or selective prosecution claim, which would require a finding of invidious discrimination. For that, I would cite the court to Van Dyke versus Village of Alsip, and that is not in the briefing, so I'll just give you the site. 819 Federal Appendix 431, decided by the Seventh Circuit
No, it's
in
not
2020.
even precedential.
I'm sorry?
It's not even precedential.
Well, I understand that, but I have searched and searched to see, is there a claim under the First Amendment based on being treated differently? And the only thing that I found is that case, and again, it's not, the H.H. Indianapolis case talks about the as-applied challenge.
It can't be cited as a precedent.
I agree with you, Your Honor. I was looking for a standard to grab onto, and that was what I found as far as in this circuit. So that's why I called it to the court's attention, but certainly it's not binding. I agree with that. Unless there's any questions, I would ask that the district court's decision be affirmed.
Thank you, counsel. Anything further, Mr. Blakelock?
May it please the court. On the preservation issue, we cited in our brief that we asserted an as-applied challenge as a part of our declaratory relief at docket 59, paragraph 78. I do want to just touch briefly on facial standing and why we're different than Monroe County in that case, and understanding the Ligon-Guth case that has been cited by the district court. The Ligon-Guth case did not involve challenge to a variance provision, which we have. We also have, like the Ligon-Guth case, we have content exemptions, but the City of Troy case said that we have a remedy around those time, place, and manner restrictions through the variance process, and our point here is that that process itself is unconstitutional. We think, following the Ligon-Guth case, that we have standing. The final point, briefly, is that we'll never know the grounds of exactly why the decision was made, which is the problem. They have to be narrow, defined, objective criteria that the variance, that the BZA is applying, and because they weren't, they can use those provisions, those broad provisions, as pretext.
Why must they be objective?
Because
The
otherwise,
criteria were not objective in Thomas against the Chicago Park District.
but the one, I mean, I think they all were, except for one potentially about danger, and danger relates to physical activity as opposed to
It relates to something, but it's not objective. There's no quantitative way of figuring this out.
danger.
There's no quantitative way. They didn't say, for example, that your demonstration will be okay if we think that fewer than 5 people will die, but bad if more than 5 people will die, right? It's not quantitative. And the Supreme Court said, but it's still okay. You know, it's basically the best we can do. Why isn't that equally true of the Evansville variance procedure?
Well, a couple things. The district court, the first time around, acknowledged that there is a material breadth of those provisions. They're not narrow at all. And when you're dealing with, there's 3 different provisions as opposed to 1. And then you also, in Evansville, unlike in the other cases like Leibenguth, you have content-based exemptions, which puts this into strict scrutiny. And so I distinguish the Thomas case on that, as well as the fact that that was on a public land and this is on private land. Unless the court has anything else, I would ask that this be reversed and set for damages.
Thank you, counsel.
Thank you.
The case is taken under advisement. Case number 4 today is Coatney against Ancestry.com. Mr. Michel.
Thank you, Your Honor, and may it please the court. Chris Michel for appellant Ancestry.com. The contractual arrangement in this case is familiar. Ancestry will process DNA samples for minors, but only if a parent or guardian accepts Ancestry's terms and conditions on the minor's behalf. That is what happened here. Plaintiffs are accordingly bound to those terms, which provide them with benefits and protections, and also require arbitration of all disputes. If the contract did
I
not...
can think of multiple ways of characterizing this. One is that you're contending that the child is directly bound because the parent was the child's agent. Second is that the parent can bind the child without being an agent, just by virtue of being a parent. And the third is a form of third-party beneficiary argument. Which one of these are you making?
Your Honor, I think we're making number 2 and number 3. Principally well, I shouldn't say principally, but first, the second one, which is that the parent or guardian bound the minor by virtue of being a parent or guardian under the terms of this contract. We're not relying on a strict agency theory. We also have an alternative argument that if the court didn't rely on the contract, equity, the third-party beneficiary, or closely related test would lead to the same results.
I don't know why you describe that as equity. Third-party beneficiary is part of the law of contracts.
I agree with that, Your Honor. We also have a third equitable argument, which is an estoppel argument, but I think you're right to characterize the second one as part of the law of contracts. I think to start with the first one, there are multiple aspects of the text of the contract that indicate the arrangement here reflects the familiar one where a parent or guardian binds the minor. If you start, the first reference to the minor explains that parents or guardians can create an account, quote, for the minor that is directly managed by the parent or guardian, and that the account manager has to represent that they are the parent or guardian. It goes on to say that they must also represent that the minor has consented to the collection and processing of the DNA, all of which is consistent with the familiar parent-guardian binding relationship.
Why would that be necessary? If the parent acts for the minor, why is the minor's consent even relevant?
I think the minor's consent is an extra protection that is built into the contract.
But something I don't understand. The minor cannot consent. That's what happens because you're a minor.
I agree with that, Your Honor. I think that's an important backdrop to the entire case. What the minor consents to here, to be clear, is not the contract. What the minor consents to is the collection and processing of the DNA, but I agree with you that that provision is ultimately not dispositive because the parent or guardian could bind the minor in any event. The activation pages, I think, further confirm that relationship. They speak about the minor as the participant and the parent or guardian as the legal representative. They refer to the parent or guardian accepting invitations on behalf of the minor. And finally, there's the use of the word "you" in the contract, which in many different places is used in a way that can only be referring to the person who's providing the DNA sample. For example, your genetic information, your saliva, and that has to be referring to the minor in this case who is providing the DNA sample, and thus the parent accepting it on the minor's behalf. I think that's a familiar arrangement, and applying it in this case would require the court to break no new ground. I think the argument on the other side is rather troubling because, among other things, it fails to make sense of the contract's text, including those usages of the word "you" that I just referred to. It would also lead to the counterintuitive result that the minors are unable to enforce, either by themselves or through their parents, any of the benefits and protections of the contract.
I didn't understand that argument. Minors can ratify contracts, right? A contract made by a minor is said to be voidable, meaning the minor can take the benefits but not the detriments. But of course, you don't have that situation. You have the parent contracting.
I agree with that, Your Honor. And as the court said in the recent KFC versus SNAP case, any youth-based defense would be an issue for the arbitrator, not an issue at this stage of the case. A final incongruity that I think is created by the other side's position is that only minors would be exempt from the arbitration clause, even though they're bringing, as this case demonstrates, the exact same claims that an adult could bring. There is, after all, nothing about the underlying claims in this case that have anything to do with minors. In fact, I think the better understanding of the suit is that it's an attempt to evade.
Let's forget about arbitration. As I understand what the district court held, it's that when a parent contracts for a child, only the parent is subject to the contract's terms. So the child gets the benefits but not the detriments. There must be some cases in Illinois of that kind. A parent buys a phone for a child, accepts the contract for the child, and the contract has in it a limited warranty. The warranty runs for 3 years, not forever. There must be some case where the child has sought warranty coverage in year 4 and said, the parent agreed to a 3-year warranty. I did not. So the limitation under the UCC, warranties last forever unless they're limited by contract. So the suit would say the child is not bound by the limited warranty. There must be cases like that. The briefs don't discuss them. I did a quick look, didn't find any. Are there any such cases?
Your Honor, we looked as well, and there are fewer than, we didn't find any. I think that reflects that this situation where the minor and the guardian depart in their interests, as was presented in your hypothetical, is a relatively rare one. Of course,
you'd think it would be more common. Here's another one. A parent buys a car for the minor child. The child is 17, and the car has to be paid for. And it isn't. And a company arrives to take the car away, and the child says, no, I get the benefit of the contract, which is the car, and only my parents are bound to pay, so you can't take the car back. It can't be repossessed. You would expect you would see cases like that in bankruptcy, if no place else, and it's a puzzle they're not findable.
I agree with that, Your Honor. It is a puzzle. I think the best Illinois case we could find, which is, of course, a district court case applying Illinois law, is the Burns case. Even there was, it's not quite as you posited. It was instead the estate of the child that was creating a conflict with the parent or guardian. But to return to an earlier point, I think any disputes like that would, at a minimum, be for the arbitrator. And instead, what's clear here is
no. That's why I said forget about arbitration. I give you this car company. Whether the car can be repossessed is not for any arbitrator. It's for a court. And that's why I'm surprised. You know, if there's nothing there, there's nothing there.
The other thing I would point
Unlike an AI, we can't just make it up.
It's true. It has arisen occasionally in other states. We cited those cases in our briefs. They all, I think, tellingly come out the same way, which is the same way that the Burns case did, differently than the district court did here, which is that the parent or guardian does bind the minor in those scenarios.
Do you have an Illinois case where it shows that the parent can bind a minor?
Well, I think the Burns case is our best example. That is a Northern District of Illinois case, but it's applying Illinois law.
Yeah.
As Judge Easterbrook suggested, the case books are not as filled with these cases as you might expect. But I do think that's partly because this is such a familiar arrangement and so rarely creates problems that these cases aren't litigated very often. And I think applying the more familiar understanding is all the court has to do here. Of course, if the court were not inclined to apply the contract, we do think the third-party beneficiary argument is a very strong fallback. It's hard to think of a party that could be more closely related to a contract.
Where's the benefit to the child in this case?
There are several benefits to the child. One very direct one is receipt of the DNA report, which describes...
So a 7-year-old needs, that's a benefit that a 7-year-old has?
I think even for a young minor, which of course I think is a more rare circumstance, but even then that would be a benefit to the 7-year-old. Of course, the 7-year-old's genetic history is not going to change, so that report will be there for the 7-year-old, even if he doesn't read it until he's older.
We should look to when they're going to be 21? Is that when the benefit vests, when they're an age recognition?
I think they could receive. I think a 7-year-old could receive a benefit, or a 10-year-old from reading a contract from reading a report like that. There are also important benefits in the contract in terms of privacy and protection of the information too, and those are benefits that accrue directly to the minor.
Further to Judge Flom's question, SA 122, there shall be no third-party beneficiaries to this agreement. How do you handle that language?
Sure. I think this court in the American United Logistics case and the Illinois Appellate Court in the Barba case have both said that generic third-party beneficiary or no third-party beneficiary clauses like that can give way to more specific references to third-party beneficiaries in the contract. And so here, although that's rare, this is the rare case where that standard is satisfied because the minor is directly referenced in the agreement and the minor is receiving direct benefits under the agreement. I think
So you want portions of the contract to apply, but not that particular portion?
Well, I would say we're applying the more specific portion, which governs over the more general portion, which is an accepted contract principle.
This concept of closely related obviously is in the case law, and there's a facial attraction to the idea of parent-child closely related. But when we look at the cases, like the Everett case or the AD case, it's setting forth a spectrum here of what is closely related. Again, is there an Illinois case that talks about this type of a relationship qualifying as closely related, either in that equitable or the direct beneficiary context?
I think that there's not a lot directly from Illinois. This court's decision in the Adams case, I think, is helpful. It talks about how to apply the closely related test. In that case, the court seems to set down a rule that a parent and a subsidiary corporation will almost always be closely related. We think that's applicable here because, of course, in that circumstance, there's an analogy between a parent and a subsidiary corporation. Here, there's a real relationship between the guardian and the minor. And so I don't think the court needs to explore the outer contours of what it could mean to be closely related to conclude that the minor who's submitting his or her DNA, it's hard to imagine something more personal than that, and is in fact the sole purpose of the contract, falls within the closely related test. I think that would be well within this court's interpretation of that test in many prior cases.
Mm-hmm. Thank you, counsel.
Thank you.
Mr. Gerby.
Good morning, and may it please the court. My name is David Gerby. I represent minor plaintiffs appellees in this case. As this court knows, this case relates to minor plaintiffs who brought claims under the Illinois Genetic Information Privacy Act for the alleged illegal release and disclosure of their genetic information through what we believe is a dystopian acquisition, whereby one of the largest private equity firms in the world, Blackstone Inc., has purchased one of the largest troves of genetic information to ever exist.
I don't see what bearing that has. I'd like you to address the same questions I was asking to your adversary, right? Suppose that a parent buys a phone for a child and the contract says there's a 2-year limited warranty. Can the child nonetheless extend the warranty for life on the ground that only the parent agreed to the limit?
Well, I don't believe so, but the situation...
Why not, on your view?
Well, the situation in that case would concern where the actual benefit, in that case the phone, is provided to the child and used by the child for a period of time, and presumably then the child...
What in state law makes that dispositive?
Well, the receipt of the direct benefit from the contract that the parent entered into to purchase the phone.
No. I asked you a question about state law. So is there some state statute or state decision to which you would refer me? I was asking that question.
Not specifically, Your Honor.
Yeah, you don't know of any either.
That's right.
So if no statute or state decision says that that's the criterion, why would that be the criterion in state law?
Well, again, Your Honor, we do believe that state law is clear that...
Is there some other state that makes that the criterion? You know, we are playing the eerie game where we're trying to predict what the Supreme Court of Illinois would say, right? If there's a conflict in other state courts, generally we predict Illinois would go with the majority, or Indiana. So what do we know about other states?
Well, there are other states that have enforced contracts entered into by parents on behalf of minors, but it's important to look at the facts of this case where there's nothing in the...
I'm not asking about the facts of this case. I'm trying to get at legal principles, right? If the two of you agree that there is no Illinois case on point, we need to go to other jurisdictions. What do we get in other jurisdictions' case law, or statute law for that matter?
Related specifically to the provision of a benefit under a contract?
Yes, whether when a parent contracts for a child, the child can say, I get the benefits, but not the detriments.
Well, there is this concept of, which this closely related test sort of relates to, is this concept of affiliation and mutuality. And that test does try and avoid situations where one party is able to claim the benefits without having to comply with the obligations. But again, that's not the case here because no benefits are received.
Yeah, no, look, I don't think my question was unclear. If we don't have any pertinent case law in Illinois, we look elsewhere to other states. Are there some other states where you'd like us to look?
I do believe that the district court properly assessed this issue. But specifically, I don't think that other states' laws is necessary under 80 Credit 1. I believe that analysis is quite clear from this court, where the court found that the question of whether the benefit is directly provided to the minor is ultimately the most relevant. And in that case, just as in this case, the benefit derived by any minor stemmed from the parent-minor relationship, not from the minor's relationship with the party with which the parent contracted.
Are there even any allegations that the minors received anything here?
No, there's no allegations in the record at all that the minors have received anything. There's no allegations that they even accessed the accounts, that they could access the accounts, and in fact, that's one of the things we allege in our brief is that there's not even a mechanism in the contract that would at any point permit the minor plaintiffs to access their results at any point at the age of majority or 21 or 18. And even appellant admits so in their brief. We make this argument and they say, well, the mechanism is obvious that they can receive the results from their parent. Well, that's exactly the point, is that the benefit, any benefit is not coming mechanically by operation of the agreement. It's coming at the election of the parents, maybe someday if they so choose. The language of the contract, which the court found, the district court found helpful, is also clear that defendant itself, in drafting the agreement, said that when a minor uses the websites, the parent or guardian will be held responsible for the minor's actions. Presumably, that's because when defendant drafted the contract, it knew that it could not force minor plaintiffs or any minors whose DNA had been provided to them to comply with the obligations that the actual account holder would presumably have to comply with. So
Ancestry.com is pointing us towards the closely related test, closely rated so it's foreseeable that the non-party would be bound. We have a case called Hugel. Close relation, parent-child, how can you get closer?
Well, so those cases are interesting, and the closely related question, which this court did note in the Romson case in a footnote, is really more of an umbrella term that is used to identify other principles in equity that could tend to bind. In those examples, typically focus on a true principal-agent relationship.
It's usually a commercial relationship.
That's right, commercial relationship, a principal-agent relationship, or parent and subsidiary from a corporation perspective. And in those cases, it's clear that the court that the test and the question of foreseeability is meant to prevent a situation in which a parent or subsidiary can foresee one of their affiliated entities being bound by terms and then try and transfer those away from them and retaining the benefits. Obviously here that's not the case, where you have minor plaintiffs who have a parent-child relationship. They aren't in the situation of even knowing what a contract is, much less that one exists between the parent potentially related to their information. Similarly, the foreseeability is again, it's the children in this case could not foresee having been bound by anything. But obviously in a corporate situation, it's quite obvious when a company may be themselves, they may foresee the potential of being bound by terms, particularly where they're a sophisticated entity and there is a back and forth negotiation related to the contracts at issue. Obviously here, this is a boilerplate agreement. There was no negotiation between our clients or even our clients' guardians and the defendant. It's boilerplate click-wrap agreement. Minor plaintiffs, again, in many cases don't even know what a contract is, much less that they could be bound by it. And indeed, that's exactly what the district court found here, is that there's nothing in the terms of the contract that would, even in the other cases, including I think there's nothing in the other cases where rather the language here, there's nothing that would indicate to the reader, meaning the parent in this case, that they are agreeing to the terms on behalf of anybody else. The language in the contract doesn't use on behalf of anybody else, and it doesn't say you're executing or entering into this agreement on behalf of anybody else. And I'd like to make another point, which is also directly relevant, related specifically to AD Credit 1. In AD Credit 1 from 2018 by this court, in the contracted issue there, the contract did provide for a situation where someone who uses the credit card, in that case it was a minor who used the credit card at the direction of the mother to purchase smoothies, can become an authorized user under the agreement. And nevertheless, the court found that no benefit was provided. That benefit that was provided through the parent-child relationship and not through the contractual relationship with the agreement. Similarly here, this is an even easier case, because in this contract, there's nothing in the terms that say, by spitting in this tube as requested by your parents, you agree to be bound by these terms and conditions, or you become a user of the services and therefore you're bound by them. Simply put, the district court correctly found that no benefit was provided to the minor plaintiffs in this case, and nothing in the contractual language of the agreement would indicate that there was an intention for them to be bound. In fact, the language says specifically the opposite, that there are to be no third-party beneficiaries, and defendant itself knew that it would not be able to enforce any obligations against the minors. If there's no further questions, that's all I have.
Thank you, counsel.
Thank you.
Case is taken under advisement. Martin against Helling is the next case for argument. Mr. Andelman.
Thank you, Your Honor. May it please the court, my name is Robert Andelman, and I represent the appellant Susie Martin in this case. Ms. Martin's case should not have been dismissed in this case. Defendants published and republished statements that she's a criminal and that people should not do business with her or any company with which she's associated. They rendered her ineligible to even bid for the work on which she had built her business. And though Ms. Martin stood trial and was acquitted of any criminal conduct concerning the allegations in the OEIG report, which is not a mean feat in this building, defendants are generally not acquitted, defendants refused to withdraw their statements or give Ms. Martin an opportunity to clear her name. And so she filed this complaint to do so. Then,
are you making a claim under the state law of defamation?
We are not, Your Honor, because unfortunately in Illinois, executive branch municipal officers are immune from claims for defamation. Then, disregarding the notice pleading rules, the district court went out of its way to find facts and draw conclusions against Ms. Martin and to dismiss her complaint before she had an opportunity to present evidence. And it was wrong for the district court to ignore or infer away her factual allegations. Its dismissal should be reversed. There are two core issues I want to focus on today, the primary one being that Ms. Martin has plausibly alleged that defendants' conduct, as frankly it was intended to do, has had a tangible impact on her employment opportunities. And that is the standard, a tangible impact on her employment opportunities. And second, that Ms. Martin alleged facts.
Where does that standard come from?
Well, originally I believe it comes from Roth versus Board of Regents. This court, in its first decision recognizing this claim in Larry versus...
the Board of Regents had absolutely nothing to do with defamation.
I was talking about the tangible impact on employment.
Property interest.
I was just talking about tangible impact on employment opportunities. It's also in this court's decision in Larry versus Lawler, which was the first time, I believe, that this court recognized these so-called stigma plus occupational liberty claims. There isn't any dispute in this record that Ms. Martin was stigmatized by the publication and then republication.
So you think the district judge was just making it all up when he said the detriment must be so great that somebody could no longer practice her chosen profession?
What I think happened, Your Honor, is
There's certainly a lot of language in the cases to that effect.
Well, there's language in the cases that use the terminology virtually impossible. What the district court did in this case was interpret that to mean actually impossible. And ultimately, the standard is one of tangible impact.
And so what is your best case for that? You're essentially saying the district court and this court, when we continue to describe this constitutional tort, just don't understand what the real rules are.
Absolutely not, Your Honor. What I would do...
So we've said this a lot of times, and what you've just said is, well, that should all just be ignored in favor of a different test.
So my view is that when I read cases, I look to what they do and not just to the words, because judges are not legislators, and so it is what they hold, what they do, that matters. So when I look at the cases that have either allowed or not allowed these, mostly, by the way, on summary judgment, because almost all of the cases the parties cite here did state claims, but things like debarment by a single agency, that's not sufficient. Like in blackout seal coding, which I believe you wrote, Your Honor. Townsend versus Vallis, that was a summary judgment case. There was no evidence.
I don't understand your test, because debarment by one agency is certainly material. It's a material detriment.
Well, in blackout, the point was it was only one municipal agency. Here, Ms. Martin was fired.
It tells us that material detriment does not suffice.
Well, the point is just debarment by CTA in that case. There was.
I think you need to focus your argument on what the courts are saying rather than a test that you will find very hard to take out of those cases.
Your Honor, even in Leary versus Lawler, just to get back to sort of first principles in this, the issue there was a 3-year suspension from an employer, their federal government, right, across all agencies is what this court said. And in that case, the court stated, we hold the loss of future employment opportunities, coupled with stigma, now burdening Larry, amounts to a foreclosure of opportunities reaching the level of a liberty interest. Those are the words that this court used in establishing this standard. In Townsend, where ultimately summary judgment was granted, the case went forward based on the fact that, summary judgment was granted because there wasn't ultimately evidence of an attempt to find new work. In Chicago United Industries, it was an 8-day debarment. That's it, 8 days. But it still stated a claim. It was only resolved on summary judgment. The problem in this case is that the district court did to Ms. Martin exactly what the defendants did. It refused to let her present evidence to try to make her case and clear her name. It went out of its way to find facts that weren't in the record and ignored the facts that were pleaded in order to reach a predetermined result. And that's wrong. She should have been allowed the opportunity to present her evidence and either at trial or summary judgment have the case resolved then. And I think here, on the facts in this case, the allegations are that the OEIG intended to have a tangible impact on her. It issued its report before it completed its investigation, contrary to Illinois law, specifically to UIC only to prevent her from getting a new contract at UIC. And then UIC responded by saying, well, we could debar her, but that would require giving her notice and an opportunity, so we'll keep it quiet for you. But then they did a shadow debarment, which she didn't learn about until years later when a subcontractor told her, we'd like to hire you, but we've been told by UIC that we can't, because they avoided exactly the process that she was due. And the same thing happened with CHA. UIC republished the conclusions of the OIG to CHA, and they debarred her without any process. And when she asked for a hearing, an opportunity to clear her name, as she had done in her criminal case where she was acquitted, they said nothing. They wouldn't give her a hearing. And the same thing with CPS. The intent here was to have a devastating impact on her business, and that's exactly what happened. And we pleaded specific facts. $21 million of contracts lost. A 3-year, or more than a 3-year, a multi-year bar that's still ongoing from contracting. This case is so far and above the fact patterns that have been held sufficient, at least to get to summary judgment in the circuit. It was plain error for the district court to rule as he did.
Large debate here, counsel, on chosen field.
Yes.
Can you give another example of a particular localized geographical area that was in a chosen field?
Your Honor, I can't give an example where it's only localized, but I know, for example, in Larry versus Lawler, the court said if you're locked out of federal employment, that's sufficient. In the Purdue case, Doe versus Purdue, it was just one university. There wasn't any and there the case was allowed to go forward on a motion to dismiss. There was never a requirement. Well, what about Indiana University? What about University of Illinois? There wasn't that requirement. And similarly, another issue in Doe was ineligibility for ROTC, the scholarship. But the court didn't say, well, what other scholarships were available? The point is it had a material impact on the plaintiff, a tangible impact, which I would argue is ultimately the standard here, and the court held that was sufficient to at least state a claim, to give her the opportunity to make her evidence. And with regard to chosen field, what we've alleged is these public sector contracts, the state and municipal contracts, they have unique bidding requirements. There's unique rules. They frankly give opportunities to women-owned businesses that don't exist in the private sector. And she had built her business around that. It was more than 80% of it. And in terms of tangible impact, we said, look, she lost $21 million of work that would have happened over a period of years for a company that had only $7 million in annual revenue. This was it was virtually impossible for her to do it. She did it, but her constitutional rights should not vary based on her resiliency and strength or the money that she was willing to put in to completely retool her business. And that, Your Honor, is why we believe the district court erred, and she should be given this opportunity to present her evidence. If they can disprove it, if they can prove, chosen field should be construed more narrowly, okay, what are the facts that allow that? But the district court doesn't have any knowledge about the elevator repair and maintenance business, and he wasn't in a position to define it as he did.
Thank you, counsel.
Thank you.
Mr. Sheffield.
Good morning, Your Honors. Jonathan Sheffield, representing Appellee, Susan Haling as Executive Inspector General, and presenting argument on her behalf, as well as on behalf of Michelle Casey, the Executive Director of the Executive Ethics Commission. I'll argue for up to 7 minutes, and counsel for CHA will present argument for the remaining time. The Board and Edwards are not presenting argument today. This court should affirm the dismissal of Martin's procedural due process claim because the district court properly concluded that she failed to plead a denial of her occupational liberty. To do so, Martin was required to plausibly allege that Appellees altered her legal status and made it virtually impossible for her to work in her chosen occupation. Martin failed to plead both elements of the claim as explained in the briefs of Haling and Casey, and although her pleading problems are universal, such as her implausible pleading that it was virtually impossible for her to continue her work, I will be specific to my argument today will be specific to the report and its publication, the report issued by the Office of the Inspector General and publication of that by the Commission. As the district court rightly noted, the allegations showed that it was not virtually impossible for Martin to find work in her chosen occupation, namely the elevator service and repair business. To plausibly allege that it was virtually impossible, she had to she had to be frozen out of all meaningful employment opportunities in her field. And that's a high hurdle, this court has said. And she really failed for two reasons. The first, as we noted, is that she still remains employed in Smart Elevators. This is her claim, not a claim on behalf of Smart Elevators. She still works for the company. And Smart Elevators, the second reason, is still working in that same occupation, the elevator service.
Why does that matter? Smart Elevators is an independent entity, right? Just as Martin can't sue on behalf of Smart Elevators, I don't see why the state can use the fact that Smart Elevators is working against Martin. Martin is an employee and investor, but Smart Elevators is itself.
Well, if Smart Elevators' continued work in the elevator service and repair field doesn't show that it's virtually impossible, then her maintaining employment for the company must show that it's virtually impossible. The state didn't do anything to make the company fire her or suspend her. There wasn't a non-rehiring question. So if this court, it could either avoid having to decide that she can bring a claim on behalf of Smart Elevators.
No, she can't.
Right.
Right? She is an investor, right? She certainly can't bring and hasn't tried to bring a shareholder's derivative claim, right? She's suing in her own name. Smart Elevators is not a party.
And so, Your Honor, then it is not virtually impossible for her to continue working for Smart Elevators. Her career being the leader of this company has not been blocked or has not been stopped in any way. So she pleaded herself out of court by noting that she maintains this employment, even if she herself lost some revenue because of the lost business, which is unclear in the complaint, that would not be enough either. And just to be clear, Your Honors, there was a question about tangible impact on employment opportunities being the standard, and of course, the standards really are virtual impossibility and altering legal status. And maybe that's what was meant by tangible impact was altering legal status. But the OEIG's report did not do that to Martin herself or her business, for what it's worth.
I should have asked this question of your adversary, but is there any reason to distinguish between an inspector general's report and an indictment for this purpose?
Yes, Your Honor, there is, because the report is issued to a specific entity. The entity decides what corrective action to take. This, Your Honor, is under Illinois law. Section 20-50 B and C make clear that if the entity decides not to take some corrective action and the executive inspector...
My question obviously wasn't clear. Both the inspector general's report and an indictment charge crime. Martin was indicted. It's a charge of crime based on probable cause, but without a prior hearing. The question is whether there is a constitutional reason to distinguish between the two.
Well, yes, Your Honor, because the way that the report functions under Illinois law, it does not operate the same as a criminal indictment. The agency has the discretion to act on it.
You're just not getting it. I'm not asking whether they are the same document. I'm asking whether there is a constitutional distinction between them so that it would be necessary to have notice and an opportunity for a hearing before one, but not the other. As I say, I should have asked this question of your adversary.
I think that there still is a constitutionally distinction between the report and an indictment, such that the report itself does not do anything to the individual. There are steps along the process that do. For instance, the university's decision not to rehire.
It sounds like you're saying there's less need for a hearing before an inspector general's report than before an indictment. But we know what the process is for an indictment, and it does not involve an adversarial hearing.
So, right, there is not an adversarial hearing before an indictment, and that would change the legal status. So again, the difference here, though, is that there is an opportunity for what it's worth under the Illinois regime for the opportunity to speak, but it's after the university gets that report and then decides, for instance, when the commission decides that it would publish the report, there is an opportunity for that response. So this is really a first step in the regime. It would be more like maybe the filing. I see my time has elapsed, Your Honor. I yield the remainder of my time and ask that you affirm.
Thank you, Mr. Sheffield. Ms. Kelly.
May it please the court, Patricia Kelly on behalf of the Chicago Housing Authority, and I'm accompanied here by counsel for the Chicago Housing Authority representing Mark Litchka and Michael Moran on the individual claims, Cynthia Harris. We join and adopt the arguments of Susan Haling to affirm the district court ruling. Their brief was filed we were almost at the same time when we filed a brief, and so we now adopt the arguments that they made in their written brief as well as the arguments that they've made before the court today. We also rely on briefs that we've joined in, that we filed in our brief. We've joined in arguments of the other defendants in support of the district court decision to dismiss the amended complaint with prejudice. We just want to raise a couple of minor, relatively brief points. One, that under Palka versus Shelton, the court requires that the potentially harmful information be disseminated publicly. Here, the appellant has stated that UIC republished to CHE, that UIC republished CHA. But what's lacking here is any publication by CHA itself. What the appellant has stated is that in argument that they've actually exaggerated their own allegations. Specifically, at page 6 of their reply, they state the CHA told contractors who were potential employees, including CCCJV, including CCCJV, that Martin engaged in bribery. CCCJV was actually the contractor who did business with CHA. In fact, that was because Martin was its subcontractor. Actually, they allege, though, in their complaint that on information and belief, unknown employees of CHA publicized statements in the OEIG report. This is in the appendix at page 16, paragraph 76. Their citation to Flores versus United Airlines did not help them. It confines the use of information and belief to matters that are peculiarly within the knowledge of the defendant. This is not the case here because Martin, through her company, Smart Elevators, had a relationship with her very contractor, CCCJV. We also wish to bring the court's attention to the fact that there's no factual basis, therefore alleged for allegations that any communication by CHA resulted in a refusal by any contractor to do business with Martin through her company. There are no, as to the individual claims against Moran and Lichka, there are no allegations against them of acts outside of their duties as employees of either the Office of Inspector General of CHA or by Moran as acting procurement officer at the time that he wrote the correspondence.
Thank you, Ms. Kelly.
To Ms. Martin.
The case will be taken under advisement and the court will be in recess. Your time has expired, counsel.